Part 3 of course number 3 presented by Robinson Lloyd Career Training Institute. In this video, I'm going to discuss referral fees. There's a Wisconsin statute that lays down the law for referral fees and commissions. The statute is simple. It states, no licensee may pay a fee or a commission or any part thereof for performing any act specified in this chapter, or as compensation for a referral or as a finder's fee to any person who's not licensed or who is not regularly and lawfully engaged in the real estate brokerage business in any other state, a territory or possession of the United States, or a foreign country. Any fees, commissions, or finder fees must be paid to the brokerage firm, not to the sales agent. So let's say you make an agreement with an unlicensed person to pay that person a finder's fee because they sent one of their friends to you who wants to buy a house. After you find that house for the buyer and the transaction closes, then the unlicensed person comes to you and says, hey, where's my cut? Well, if you pay it, you're violating the law. But if you're thinking about the fact that you shouldn't to save your license, you don't even have to pay it because under the law, any agreement to pay a brokerage commission to an unlicensed person is void when the agreement is made. That person wouldn't even bother filing a complaint if they knew the law because they'd lose because you followed the law. There's case law on that issue out of the Wisconsin Court of Appeals, which was a 1995 case. The issue is whether an out-of-state real estate broker can collect a commission for brokerage work performed in Wisconsin, even though that broker is not licensed in the state, by having that commission first pass through the hands of a licensed Wisconsin broker when that broker does nothing more than act as a conduit for the commission. Well, in that case, an Illinois real estate broker was hired to negotiate rental space with a potential lessee in a downtown Milwaukee office building. The Illinois broker was not licensed in Wisconsin. So to secure his commission, the Illinois broker struck a deal with a Wisconsin attorney who was also a broker to collect the commission and then give the commission to the Illinois broker. There was a brokerage commission agreement executed by the lessor, the attorney broker, and the Illinois broker. At that time, there was a law in Wisconsin that prohibited out-of-state brokers from collecting a commission from a Wisconsin transaction if the Illinois broker was not licensed in Wisconsin. Well, the court in its decision cited the statute at the time and said that the Illinois broker was not entitled to a commission because the Illinois broker didn't do anything to earn a commission. They said that the attorney broker didn't supervise the Illinois broker, nor did he work with him as a co-broker. The only role that the attorney broker had was to be the conduit to get the commission to the Illinois broker. Instead, what they did do was act together to circumvent the statute, the court said. This arrangement is like a Wisconsin broker subletting their license without any attendant responsibility. The court stated that neither the attorney broker nor the Illinois broker were entitled to a commission. So under the law, you can't pay a fee or a commission for or any part of a commission for performing any brokerage act or even a referral fee or finder's fee to anyone who's not licensed or registered as a licensee or who is not regularly engaged in brokerage in another state, territory, or possession of the U.S. or a foreign country. What if you're only licensed as a salesperson? Can you collect a finder's fee? Well, the answer, and you should know this, is no. The commission must go through your brokerage firm first. Well, how do you operate the correct way? If you're going to receive a referral fee, you should always get the terms in writing. Some of the things that you should make sure that are part of the referral agreement is the name and contact information of the party that you're referring to the other broker or vice versa. You should also enter the names of the referring and receiving agents and their brokers in the agreement. It's also a good idea to include written confirmation of licensure. Compute the referral fee amount and who's paying the fee and when it's to be paid. Also, indicate what needs to happen to earn the commission and cite the term of the agreement in the written agreement that you make. What about referral fees from some other service other than a broker? Let's say you recommend that a seller use a specific basement contractor to correct basement issues, and the contractor is willing to pay you a referral fee if the seller utilizes their service. Well, can you do that? Can you do that? Do you know the answer to that one? Yes, you can, but the compensation that's paid to you must be disclosed to the party that will receive the service. You must disclose any financial benefits or fees. For example, here's another one. Let's say you refer a landscaper to your seller to clean up the yard. In exchange, the landscaper will plant a tree for you for free. Does this financial benefit need to be disclosed? Well, you can figure that one out. The answer is yes. The arrangement must be disclosed to the party. On its website, the DSPS answers these questions regarding fees, and you can look them up. Can a real estate salesperson or timeshare salesperson offer a finder's fee to people who make successful referrals to a broker? The answer is what Wisconsin 452.19 says. It prohibits a finder's fee or a commission to a person not licensed as a salesperson or broker. But there are no restrictions on the licensee giving a gift or an incentive to a buyer or a seller. Here's another DSPS question. If a licensed real estate salesperson facilitates the sale of his or her own property or the purchase of a new property for his or her personal use, can that salesperson receive a portion of the typical sales commission? Well, the Real Estate Examining Board says that a licensee acting on his or her behalf for the sale or purchase of a property may not collect a commission unless he or she obtains the written consent of all the parties to the transaction. You also have to disclose your license status and intent to act in the transaction at the first showing of the property, the first contact with the other party or agent, or any other negotiation. Can a broker receive the interest earned from any real estate trust account? The answer is absolutely not. None of the interest earned on the deposited funds into an interest-bearing account can be taken by the broker. What types of referral fees are available to you? Well, if we made a pie chart, the largest amount of referrals are generated from past client referrals. And the three other types of referrals are from local businesses, agent-to-agent referrals, and relocation company referrals. Referrals from local businesses take a long time to develop. You're cultivating relationships over time, but it pays off in the end. Relocation referrals are mostly derived from families that are moving into a different locale, families or anybody else. Relocation companies are always seeking out agents to help their clients find a home in a new location. And in today's job market, relocation is most likely getting more lucrative because due to many people working out of their homes now, they can actually move to any location they choose. It doesn't matter because they don't go to an office to work. Past client referrals are one of the best ways to develop new clients. Agent-to-agent referrals work out to be probably the best type of referral you can receive. This referral usually starts with an agent in another state having a client that's moving to another locale. The local agent finds an agent in that locale to work with their client. Both agents receive commissions in most cases. Let's talk about kickbacks or referral fees as it applies to RESPA. In the Real Estate Settlement and Procedures Act, there are prohibitions under Section 8 of the Act when it comes to kickbacks and referral fees. The Act prohibits giving or accepting a fee, kickback, or thing of value per an agreement or understanding, oral or otherwise, for business referrals involving federal-related mortgage loans. What's the definition of a thing of value? Well, it includes money, things, discounts, salaries, commissions, fees, duplicate payments of a charge, stock dividends, distributions of a partnership profit, franchise royalties, credits representing monies that can be paid at a future date, the opportunity to participate in a money-making program, retained or increased earnings, increased equity in a parent or subsidiary entity, special bank deposits or accounts, special or unusual banking terms, fee rates, sales or rentals at special prices, trips, payment of another person's expenses, reduction in credit against an existing obligation. These referral prohibitions are not limited to just those consumers that you direct to a lender. They can be directed to appraisers, attorney legal services, real estate agents, of course, title companies and agents, lenders, mortgage brokers, or companies that provide information in connection with settlements, such as credit reports and flood determinations. Gifts and promotions could be considered in violation of RESPA. Both are considered things of value and, depending on the circumstances, can violate RESPA Section 8A. If the gifts or referrals are given or accepted under an agreement or understanding for referral of business as part of a real estate settlement service, they're prohibited. But there's a safe harbor provision that allows for an affiliated service provider referral, but there are 3 requirements that must be met. You must have a mandatory disclosure statement. There can be no requirement for use of the affiliated settlement service business. And there can be no compensation other than return on ownership. If you're involved in an area regulated by RESPA, there are good publications that can guide you. You should look them up. You can find those regulations online. Well, that sums up part 3 of course number 3. I'll see you in part 4, which is the review for course number 3.